Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and today we're joined with our host Jim York and his guest Donald Ross Jr., President and CEO of Ross Title and Escrow.
Thank you, Morgan, for the introduction. Well, Don, welcome to the show
Jim,
today.
thank you.
Long time no see.
Yeah, what have you been up to? Anything fun?
Not much. So,
Nothing you could talk about on TV, I guess?
Exactly. So for the viewers that haven't seen you, let's tell them a little bit about yourself.
I'm a real estate attorney in Naples, tax lawyer as well. I'm the attorney for Downing Fry Realty, have been for about 30 years. I've been in town since '85, been an attorney since '81. Do almost exclusively residential real estate closings with an overtone of taxation for the non-residents. Own Ross Title and Escrow. I have my son Christian joining. He's flying down next Wednesday, actually. It'll be Ross and Ross.
Oh, really?
In the law firm. So let him do some hard work.
Earlier than I thought. I thought it was January. So
He's coming down early.
well, that's good.
But 8 people do a lot of closings. We keep busy. People seem to be happy.
So our viewers, if they don't understand, there's different kinds of contracts in the state of Florida. We have one
There
locally, right? And the one that we can use statewide is
Right.
FARBAR. And
Right.
in November 1st, they just came out with some changes. So that's what I'd like to talk about today, if you're familiar with those changes, Don.
I'm vaguely familiar. I was going to say, God bless the lawyers. We got some more changes. Yes, it came out November 1st, and for people who are seeing this for the first time, we're filming this on the 9th, so it's been out a little over a week. And there's a number of changes throughout the contract. They're always trying to tighten things up. But just starting from the beginning, they've added a number of things to the tangible property that goes with the sale.
Right.
The thermostats, the doorbells, the TV mounts, things like that. The reason
The doorbell goes with the house?
yes, because there's smart doorbells
Right,
now,
right.
and there's smart thermostats. So I guess people were taking them out of homes when they sold their homes,
Right.
and the buyers were getting perturbed. So they've specified that the doorbells and the thermostats, well, normally it'd be a fixture
I
under
just
the
never
case
had
law.
somebody do that, but that's
Well, I guess if you spend $1,000 for some electronic doodad on the wall, people tend to take it with them. But it's now specified that that's part of what the seller is conveying to the buyer. While they were at it, it would have been nice if they added the washer and dryer, because we have to keep adding in the washer and dryer,
Right.
the FARBAR, which is the Florida Association of Realtors and the Florida Bar. But still add the washer and dryer for those of you who are using this contract, and for your sellers, if they want to exclude their very expensive thermostat that they can control with their phone or their doorbell.
right.
And my neighbor, he's a dual citizen of Italy, and if you ring his doorbell, he can watch you on his smartphone while he's sitting in Italy. So people tend to take those devices, or try to anyways, with them. So that was the first noticeable change that I saw.
How
in
about the
contract.
cameras, if they have cameras?
That's
is that already in there?
that's in NABOR. That would be a fixture, in my opinion. They don't specify the cameras, but
Okay.
anything screwed or
Attached,
nailed or
right.
glued to the home goes with it. The NABOR contract specifically gets into home surveillance systems, and that has to stay, home entertainment centers, that sort of thing. But it's always good. They leave space to add additional things that are going with it. So if you're a buyer and there's some confusion, you want to add it in.
Right.
If there's something that's a family heirloom, I had a chandelier for my grandmother, I would specifically exclude it so that I could keep it. But if in doubt, put it down in the contract. So that was, again, the first change that they had. The next one was they changed, and a lot of this is little geeky lawyer changes, but
Well, the doorbell wasn't.
well, I mean, the definition of closing has changed. They've gotten more specific. The funds actually have to be in the account of the closing agent, cleared funds in the account, which tells me that they've had problems in other parts of the state over, buyers saying, I wired the money and I demand, and the seller's trying to terminate the contract. So every time there's a problem in some other part of the state, they end up making a revision in the FAR contract. So they're clarifying that the closing agent, the title company, the law firm actually has to have physical possession of the money in their account. It can't just be the check's in the mail or the wire's on its way.
This is the additional funds or?
The additional funds to close.
Right, not the bank money.
No, well, you obviously you'd need that too.
You need that, but that's what they're really talking about is the buyer's funds.
Right, so they've had that problem. They've got an interesting thing on that they've added. You can extend the closing date under the FAR contract if you have checked the financing contingency in 8B. It's paragraph 8B. And the underwriting, you get up to 7 more days on the CFPB rules, the Consumer Finance Protection Bureau. Just like we have in NABOR. NABOR, they give us 10 days. But in FAR, they specify that the underwriting has to be all done, and the loan approval was already obtained by the buyer. So you don't automatically get up to 7 days. You have to have the underwriting finished. They can't still be working on it. And you must have loan approval in order to get up to 7 days. So that's a little bit different than NABOR, so that's useful.
Yeah, I think it is.
Yeah. Assignability. It's another one of those NABOR-FAR comparisons with the NABOR. We have on page 3, I think it is, instructions on taking title. It talks about how 15 days prior to closing, the buyer is going to tell the seller how they're going to take title, including any assignments thereof. And then it goes on to talk about, if the buyer gets the permission of the seller for this financing, then buyer number 1's off the hook. If they don't, then they're still on the hook. So if there's a condition in the contract like getting a mortgage, buyer number 1 still has to make a good faith effort. Well, in FAR, they just have a paragraph 7, which has 3 blocks. You can assign it, and be relieved of liability. You can assign it and not be relieved of liability, or you cannot assign it. Well, they added a sentence that says, if none of these blocks are checked, you can't assign it at all. And I always tell the agents, pick the middle block. You can assign it but not be relieved of liability. That's more readily accepted by the seller.
So if a person puts it in their name and they want to put it in a trust.
They want to put it in a trust. They want to add their wife. They want to put it in an LLC. One of their kids. Or they just want to, in this market, they just sell the contract.
Right, exactly right.
I mean, and I've done quite a few of those. Just, the contract is a intangible asset or a tangible asset that they can sell, like a stock or a bond.
Right.
So I've done my fair share of those. So now they specify if you don't check off a block, it's not assignable. Right. Period. End of story. You need permission. Then we get into financing. The financing clause, as we discussed in the last show, what's the polite way of putting this? I really dislike strongly because they had a thing called deemed loan approval. If you don't notify the seller within a certain time frame, whether you got the loan or you didn't, or you terminate. Here, they changed the contract, the financing clause around a little bit, that within the loan approval period, which is 30 days by default, unless you get the seller to agree to a longer time period, the buyer has a duty to make sure that the lender has their appraisal or something like an appraisal that's acceptable to the lender. I mean, some loans don't require appraisal. Some lenders will take something, evaluation by you, a realtor, whatever the heck it is that the lender requires. That in order, they have to get that loan approval or its equivalent within the 30-day period. Right. Okay. Now, if they don't get it within that 30-day period, they added an additional term that wasn't there before. The buyer can notify the seller that I don't have loan approval yet, but I'm satisfied with my prospects of getting it, and give that written notice to the seller. And that prevents the seller from terminating the contract and selling it to somebody else.
Okay.
Okay, so
Interesting.
it's a kind of a fancy waiver.
Right.
It's just, if you get down to it and, they're this close, I'm pretty sure I'm going to get it, I don't want to lose the house, you just give them notice that you're satisfied, you don't have it yet,
Right.
but you're satisfied with the prospects of getting it, and that's enough to keep the contract together and protect the buyer from the seller terminating the contract. There's another part of that clause that gets into what kind of notice the lender has to give to you, the realtor or the seller, about the progress of the loan. And they now require a written request from the seller or the broker. And the lender has to give them progress on, you don't have to worry about the appraisal because that's within the 30 days, but how they doing on the loan approval process or other property-related matters that could potentially torpedo your transaction. So that's good. So they've cleaned up the financing clause a bit, makes it less apt for a deal to fall apart. Because the way they had it before, you could have loan approval, give notice of loan approval, and then the buyer could still get out of the contract if the appraisal came in low, or if the lender found some property condition, like the roof is too old, the place is riddled with termites, sorry, we're not going to lend. And in that situation, under the old version of FAR-BAR, the buyer could still get their money back even though they gave notice of loan approval.
Interesting. So it looks like
Is
they
it really
did clean-
interesting?
Yeah. Well, what's going to be interesting, we're going to take a little short break here and hear about Don Ross and myself, and we'll be right back in a minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Donald, let's continue the show here with the FAR-BAR new updates.
The FAR-BAR, the exciting saga of the financing changes.
Yep.
When can the buyer terminate? If they don't get loan approval within the 30 days, they give notice, written notice, everything has to be in writing, or they get written notice of loan approval, but there's no way they can timely meet all the conditions of the loan in time for closing. Now, they didn't flesh out what that conceivably be, but they might have conditions in there that would be take quite a bit of time, like you need a new roof or something, and it's not going to be done in time for closing, so the buyer can terminate in that situation. So that's a new thing added to the financing clause. So
that's key.
Recap, the real substantive changes were in paragraph 8, the financing clause. Too many deals were falling apart because buyers were giving notice of loan approval, seller thought everything was great,
and then it didn't.
Then at the end you get notice that the lender appraised the property and it was too low and they're not getting the loan. And under the old version, the buyer could get their money back.
Right.
Well, now they got rid of that problem by requiring the lender and the buyer to get the appraisal done within the loan approval time period. That's really the biggest, most important part of this. Then they had a number of smaller issues. Under the FAR contract, if a deadline fell on a weekend, it used to roll over to the next business day at 5 p.m.
Right.
They got rid of the 5 p.m. So it could go for the balance of the day.
Till midnight,
It could go, like a microsecond before midnight, because then you're into the next day.
Right.
In Nabor, as we know, it goes to 11:59
That's right,
of the day. So they've kind of come into the same orbit as Nabor on that issue, which makes it a little easier. They changed force majeure clause. Now, Nabor doesn't have one, okay, but FAR does. Acts of God, acts of nature. Right. And they added a different the force majeure clause applies not only to the obligations, the buyer's obligation to buy this property, to pay for it, to get the loan and all that, but it also applies now to the rights of both parties. The buyers have, if you remember during COVID, there were some condos that would not let people have walkthroughs. Right. So now the force majeure clause would protect buyers who are not able to have a walkthrough, using that as an example, and they get more time under that clause to have their walkthrough and have their rights protected. And then the notice clause, which is something lawyers tend to get excited over, and that means me. You can give notice in writing by fax or email. Texting, social media does not count. Okay, up to this point, there's been cases, and I've written about this, that notices in writing, any sort of email, any sort of text, trying to teach those realtors who tend to communicate more by email and text that you have to be careful what you put in writing, because you might inadvertently make an election, because under Nabor, anyways, it's governed by the Electronic Signatures Act in Florida, and what's the signature under Florida law? Well, pretty much anything. Right. So you got to be real careful what you put in writing. Well, now FAR is looking at this, and it's the Florida bar mostly, if I had to guess, and they're saying certain types of electronic communications are okay for notice. The reason they don't allow text is that those can disappear over time. Right. If you look at this setting on your iPhone or your Android phone, whatever you have, goes away. Whatever you set it at, 30 days, 12 months, it wipes all that stuff clean after a certain time period. Or social media, people could take down the site. That's right. Is that notice? Yeah. So they're trying to adapt to the changing technology that we're living in, what's notice and what's not, which is helpful, because this is one of my pet things with the newer agents. Right. We had a class recently, 18-year-old, 21-year-old people in their early 20s now have their license. And that's their method of communication. Right. So, what works, what doesn't, is, they now have to specify. And the final point, I would say, they've changed the riders around, which are interesting. They actually have a mold rider now. Everything we've been talking to up to this point would apply to the FAR as is and the regular FAR, which has the general repairs, the wood destroying organisms, and the permits, the three categories, the 1.5%. They adopted a rider that gives the buyer X number of days, and it's rider I. And they do this in terms of frequency used, so I don't know how the heck they did this, because it just came out, so I don't know how. But I think they expect it's going to be used quite a bit, is probably my guess. But if you have a mold report done, you're given default language of 20 days to have a mold report done, and if it shows mold that costs more than $500 is the default language. Okay,
Yeah, 500 bucks.
$500. You can spit and spend $500.
Exactly, right.
If you give notice within the 20 days to the seller that here's the mold report, it's $622.12. The buyer can terminate the contract.
Right.
And it doesn't distinguish between allergenic mold or toxic and pathogenic mold. Like Nabor is toxic and pathogenic, and the seller has a chance to fix it. So if you're representing a buyer and you're up in Punta Gorda or Tallahassee and they have medical conditions, I would strongly recommend that. That one really leaked out. But you got to be careful. I mean, you can always play with it and limit it to toxic, depending if you're the seller or the buyer. And if you're the seller, you might want to up the amount.
Yep.
And I can already think of, well, exclude the furniture, because once they have mold, it gets into the furniture, and that costs more than the furniture is worth to remedy in some cases.
Right.
So those three things would be the balance of the really big changes I've seen. There's more. How it's going to play out, who knows? Will they have more changes? Oh, sure.
Oh, yeah.
But to summarize, the finance clause is a lot different.
Did they update their contracts every 2 years like we do?
Roughly every 2 years.
Right. That's.
Again, it's the lawyers.
Yep.
Some of it's useful. I mean, I like the finance clause being tightened up so that people don't get their hopes up and think they have a deal when they get notice of loan approval, and then get a low appraisal at the end. That's a good thing.
It is.
And specifying what kind of notice is a good thing. And the 5 o'clock rollover, getting rid of that is a good thing. And this mold addendum is a starting point, but beware, it's $500. That's a ridiculously low number.
It's ridiculous.
Unless you're in this market and you don't care if the buyer walks, you want to look at that, and you might even want to have it modified by an attorney. I'm allowed to mark it up, or the client can mark it up.
Right.
You can't mark it up as practicing law, but the client can do it, or I can do it. And there's your exciting summary of the 5-hour changes.
It's usually you did a heck of a job.
Well, it's been 1 week's notice, really. It's been out there. I'm sure there'll be more information coming out as we
but this is a nice quick summary for our viewers, and I mean, it's something that they need to be looking for, depending on whatever contract they're using. So.
The basics are the same. I mean, I've been preaching all along. You got to keep track of the timelines and then call somebody.
That's right.
Something needs to be done, like with the financing, within 30 days. Just calendar maybe 5 days before the 30 days, so you can talk to whoever's doing your closing and say, are we supposed to be doing something here?
Yeah, communication's everything.
It's everything.
Everything.
Absolutely.
Everything. Detail and communication.
Constant communication, checking with the client, checking with the lender. You sure you're ready? Where are we? Explaining it to them, because it is an incredibly complicated clause.
Your team's fantastic also. So.
Oh, thank you.
But thank you for tuning in today, and thank you, Don, for coming to the show today.
Thanks for having me, Jim.
Today,
appreciate it.
See you next week. Thank you.